What's up, everybody? So, a lot of you have been asking about the Lori Vallow Daybell sentencing. It was brutal to watch and to listen to. We are not going to listen to the 2.5 hours of victim impact statements. We're not going to um, go through every heart wrenching story about how heinous and despicable and horrible these crimes were. But I do think that it is interesting and worth discussing how the judge looked at what the victim impact statements were, how the judge looked at these crimes, whether or not to run. I mean, we know she's getting a life sentence. Is he going to pile on? Is he going to make them consecutive? Is he going to make them concurrent? And then perhaps one of the more interesting parts of the sentencing hearing was Lori Vallow Daybell speaking in open court on her own behalf, asking the court for a lesser sentence or trying to create a mitigating circumstance. I have not even watched her entire statement in its entirety yet. But on this video, we're going to watch Lori Vallow's statement, and then we're going to see how the judge rules, balancing the aggravating factors and the mitigating factors, knowing that there's no death penalty on the table. Will he bring down the harshest sentence he can? That is the main question we are looking at today. Let me know what comments you have. Let me know if you're interested in following up with what happens on appeals in the Chad Daybell case by hitting the like button. And of course, letting me know in the comments which cases you want me to follow and if this is still one, because I know that this is one that's been a really tough follow for a lot of people. I can't blame anybody for that. So that's why, again, I'm not going to go through all of the victim impact statements. There were a ton. They were effective. And everybody who watched and listened, including the court, they did their job. The public got to understand what these victims were like. They were a beautiful voice for the victims, and they will carry on their memory forever. And I think that's really important, and that is the main point of these victim impact statements. So again, letting that be known right off the jump as the by far most important thing about this sentencing. And we're going to hear again how the judge felt about them. But first, let's hear from Lori Vallow herself, whom her lawyer said is potentially the most hated woman in America right now. She has the opportunity to speak on her own behalf. So let's see what she says and what she does with her time.
I would like to start by quoting John from the New Testament in the Bible. In John chapter 8, verse 7, Jesus says, "He that is without sin among you, let him first cast a stone at her." Then in verse 15, Jesus says, "Ye judge after the flesh, I judge no man. And yet if I judge, my judgment is true."
So you without sin cast the first stone. It is a very impactful story in the Bible about how we judge others in everyday life. And when somebody else does something wrong, we realize we do a lot of things wrong too. So how harshly are we going to look at somebody? That is not a blanket statement for when people commit crimes like this. That is not a blanket statement when people commit crimes at all. The rule of law is also something that goes back to biblical times. And when you break it and you do things to hurt people, you are punished. Just because somebody else did, just because, I told a lie this week doesn't mean that somebody who commits these crimes shouldn't go to prison for the rest of their life. So that's totally out of context, makes no sense, shouldn't be convincing at all in a mitigating sentencing circumstances like this. But again, misusing scripture is something that's kind of on par with Lori Vallow.
Jesus knows me, and Jesus understands me. I mourn with all of you who mourn my children and Tammy. Jesus Christ knows the truth of what happened here. Jesus Christ knows that no one was murdered in this case. Accidental deaths happen. Suicides happen. Fatal side effects from medications happen.
So which were the children? Accidental, medical, on purpose, themselves? She referencing Tammy. Again, these vague statements that she's making and saying Jesus knows what happened are not helpful, in my opinion. The jury has convicted her at this point. It is a legal fact that she committed these crimes. And again, denying that you did them does not help you in sentencing. Most courts will have some kind of mercy on you, probably not in this situation, but there are even leveling down in sentencing guidelines for acceptance of responsibility. And she is still not doing any of that. Not saying she has to. If she still, maintains her innocence, that's totally fine. But this is not helping, arguing basically the jury got it wrong.
I have a different perspective in life because in 2002, when I was pregnant with Tylee, I died in the hospital while in labor with her. They tried to stop my labor. They put me on the table and they put something in my IV, and I felt my spirit falling to the floor. I was standing near my pregnant body, watching the doctors try to revive me, which took them a few minutes. In that time, my sister Stacy was standing to my left. I turned to hug her and was surprised that her spirit was as tangible as a physical body because I knew I was in spirit and she was in spirit. She said she needed to show me some things and we went to heaven. I later returned to my body. Because of this experience, I have access to heaven and the spirit world. Since then, I have had many communications from people now living in heaven, including my children, Tylee Ashlyn and Joshua Jackson, my sisters, Stacy and Lolly, my aunts and my uncles, and my grandparents. I've had many communications with Jesus Christ, the Savior of this world, and our heavenly parents. I've had many angelic visitors have come and communicated with me and even manifested themselves to me. Because of these communications, I know for a fact that my children are happy and busy in the spirit world. Because of my communications with...
Another thing that does not work in sentencing, saying the people that you've been convicted of ending their lives, that they're good in the spirit world. You've talked to them. Don't worry, judge. They're fine. They're happy. They're better off, judge. And while it may even be true, nobody's going to take that you are basically talking to somebody in the spirit world, and because you say they're okay now, you should not be punished for what you did to them on earth where these laws apply. So again, in case anybody's following along, not helping in the sentencing world.
My friend Tammy Daybell, I know that she is also very happy and extremely busy. I have always mourned the loss of my loved ones, and I have lost many in this mortal world. However, I know that more than most people. I know where they are now and what they're doing. I know how wonderful heaven is, and I'm homesick for it every single day. I know we all lived in heaven before we were born on earth, and we were all adult spirits in the heavenly realm. We chose to come to earth as mortals. Heaven is more wonderful than you can possibly imagine. I do not...
People have different theologies. People have different beliefs. And we live in a country where we're free to believe that and explain that. Whatever your belief is not going to get around laws that you break. And certain religions know that, their commandments are unlawful or whatever, wherever they live, right? In other countries across the world, laws are very different. Religions are very different. This argument, though, is reinforcing a lot of what the trial was about, which is also why I thought the state's theme in weaving the religious beliefs and how they turned them to be about money and power and getting bigger and becoming, the leaders, and they used that to manipulate and hurt people. I think this is just being highlighted even more, how they're using it to try to manipulate this system, right? Because that's what she's doing here. In my opinion, I should say. That's how I am hearing it.
Not fear death, but I look forward to it. I did not want to return to my body when I was out of it. Even though my son Colby, who I adored more than anything, was only 6 years old at the time, and I was about to give birth to this new baby girl that I wanted so badly. I was a young mother, and you would think I wouldn't want to leave my children, but as I stood in heaven, I did not want to go back. I thought they would be fine without me because I was peaceful and I was happy and I was home. But then I was told by Jesus that I needed to go back and complete things that I had covenanted or promised to do before I was born. This caused me a lot of distress because I knew heaven was my real home, and I only wanted to be there. I was free from pain, emotional and physical. But then I was shown how I would help my children and others in the future. So ultimately, I did agree to go back to my body. Tylee has visited me. She is happy and very busy.
Also, you can kind of understand what she would have wanted to go on in her trial, what she would have said if she testified, why she was upset with her lawyer during closing arguments, or why it seemed like she was upset. Starting to get an idea of that by hearing her statement.
Tylee is free now from all the pains of her life. Tylee suffered horrible physical pain her whole life. I sat with Tylee in the hospital year after year after year while she screamed in pain when the morphine wasn't even enough to take away the pain of her pancreatitis. I sat there while she cried and I held back her hair while she threw up. And I'm the only person on this earth who knows how much Tylee suffered in her life. She had pain every single day. She never felt good. Her body did not work right. And I don't know if that was from complications from me dying while she was being born or something else, but she had a very difficult life. She was sexually abused by her own biological father since she was 3 years old, and she was forced by family court to go visit him for 10 years against her will. I fought for her in court. I protected her. I tried to protect her with my whole life. I tried to protect her. I worried about her every single day. Tylee had to get her GED because she couldn't go to school every day because she never felt good. She felt sick. Nobody knows this because Tylee, like myself, tries to put on a good front, tries to be a happy person, tries to have hope in life, tries to know that she's here for a purpose and that she has an eternal purpose to be on this earth. But I never stopped worrying about her. One of the times that Tylee came to me as a spirit after she died, she commanded me and she said to me, "Stop worrying, Mom. We are fine." She knows how I worry and how I miss her. The first time JJ visited me after he passed away.
There's tons of things you can pick apart here and how it doesn't make sense regardless of, how you would theologically believe in how things work, and how somehow this all just works to the benefit of Lori Vallow. And it is something that makes Lori Vallow better. And that's not how it always works, right? And she's going to continue to try to convince the judge of this. You can tell we're seeing the judge's face throughout the whole speech. I don't think she's moving him at all. We'll see what he ends up saying at the end.
He put his arm around me and he said to me, "You didn't do anything wrong, Mom. I love you. And I know you loved me every minute of my life." JJ, Joshua Jackson, was an adult spirit. And he was very, very tall when he put his arm around me. He is busy. He is engaged. He has jobs that he does there. And he is happy where he is. His life was short, but JJ's life was meaningful. JJ was a wonderful person and touched the lives of everyone. And I adored him every minute of his life. My eternal friend, Tammy Daybell, has visited me on several occasions. She came to bring me peace and comfort. And I know that she is extremely busy helping her family, especially her children and grandchildren. And I have a great love for Tammy. My beautiful children, Tylee Ashlyn and Joshua Jackson, rest safely this day in the arms of Jesus. My wonderful friend, Tammy Daybell, rests safely this day in the arms of Jesus. And I look forward to the day when we are all reunited and I too will rest with them in the arms of my Jesus.
And I will always be respectful of what people believe, and I understand that, even if I disagree with it. So I just want to make sure all my comments, and I'm not going to be disrespectful. I'm not going to make fun of her. I'm not going to say it sounds crazy. I'm not going to roll my eyes, anything like that. But what I'm going to say is it does not make a legal argument for mitigation that she should get anything less than the most severe penalty in this situation based on the crimes and based on the victim impact statements. I just wanted to throw that in.
All right, Ms. Vallow, thank you for your comments to the court. Let me ask you at this time, Ms. Vallow, are you fully satisfied with the representation you've received from your attorneys throughout this case?
Yes.
Thank you.
I think she said yes.
Matter and then pronounced sentence. Ms. Vallow, based on the jury's verdict of guilty in this case, it is the judgment of this court that you're guilty of the following counts of the amended indictment. Count 1, conspiracy to commit first-degree murder of Tylee Ryan and Grant Theft. And count 7, you've ever had. I will note, however, in addition to these convictions, you have 2 additional conspiracy to commit first-degree murder cases pending in Arizona. And it's somewhat...
So he said these were her first criminal charges, but she does have other charges in other states at this point. I just want to kind of skip through to hear what he says about his sentence and why he's sentencing her to that.
Incredible in this case that seeing you've gone from no criminal history in your life to now having been convicted of 2 counts of first-degree murder, 3 counts of conspiracy to commit first-degree murder, and you continue to face more additional counts of conspiracy to commit first-degree murder in another state. I've looked at the recommendations in the pre-sentence investigation report. It ultimately recommends a prison sentence stating, quote, incarceration under the custody of the Idaho Board of Correction. Normally, the court would have some additional information to rely on in fashioning its sentence, including the benefit of recommendations based on a gain evaluation, substance abuse report, mental health review, and other reports. However, you elected not to cooperate with the pre-sentence investigation. As I would note on page 23 of the pre-sentence investigation report, it's
So she did not cooperate in the pre-sentence investigation, which usually means it's not going to go well for you, especially somebody like her who probably does have some at least mitigating factors as far as mental health goes. She wasn't competent for a large period of time throughout her litigation. I will just tell you, the judges don't look kindly on that. Some jurisdictions don't allow you to not participate, but that's not going to help her either.
States, quote, Lori Vallow Daybell intends to remain silent during the pre-sentence investigation process. She has the packet, but does not intend to answer any questions of evaluators or investigators. Quote, no attempts were made to complete the court-ordered screenings due to her refusal. I'm advising you that that was your choice to not cooperate in the pre-sentence investigation, but it left me without some additional information that potentially could have been mitigating in your case. And as I proceed with the sentencing, I'll note those deficiencies in the information I normally would have in a pre-sentence investigation report. As has been mentioned by both sides here, the court has to consider certain sentencing objectives when I sentence somebody, and these are set out in cases including State versus Hill, which is a Court of Appeals case, 103 Idaho 565, and it's been adopted by our Supreme Court as well. And I have to consider four main objectives. Number one, the protection of society, which is the primary objective. Two, deterrence of the individual and public generally. Three, possibility of rehabilitation. And four, punishment or retribution for wrongdoing. That case states, moreover, it's clear as a matter of policy in Idaho, the primary consideration is the good order and protection of society. All other factors must be subservient to that end. I've also reviewed and considered the criteria.
We've watched a lot of sentencings at this point. Main factors here: protecting society, rehabilitation, other things that he mentioned. But in this situation with this heinous of a crime and other pending crimes, protecting society is most important.
Criteria set forth in an Idaho statute, 1925-21, on the question of whether or not you should be confined to prison and to what extent. And that statute sets out a variety of factors I have to consider in weighing whether a long prison term here would be appropriate. Some of the attorneys cited already to some of the provisions of that statute. And again, it talks about the primary consideration of the protection of society, and also talks about the impact on the victim. The possibility of risk reduction through rehabilitation and deterrence are also to be considered. There are some factors laid out in that statute that are not necessarily controlling, but weigh in favor against either imprisonment, or in this case, where imprisonment is required, an extensive imprisonment term. Some of those factors under Part 2 of the statute is the defendant's criminal conduct neither caused nor threatened harm, which is clearly not the case here. That the defendant did not contemplate the conduct would cause or threaten harm. Again, that would not apply here. The defendant's criminogenic needs indicate the defendant will benefit from supervision and treatment in the community. That's unavailable, as community treatment can't occur with a minimum prison sentence required here. Another factor, were there substantial grounds tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. I don't find those apply given the facts of this case.
So these are all the mitigating factors. So any of these things would make a less harsh penalty. We know she's getting life, okay? So this is just kind of a educating moment for all of us. But he's reading through and telling them why these mitigating factors don't apply to her. And some of them he doesn't even have the information because she didn't cooperate in the pre-sentence investigation.
Other factors, the victim of the defendant's criminal conduct induced or facilitated the commission of the crime. That did not occur here. Another part talks about compensation, which I don't find would be appropriate here other than on the grand theft charge. Part G, the defendant has no history of prior delinquency or criminal activity, or has led a law-abiding life for a substantial period of time before the commission of the present crime. That is the single most mitigating factor I see in this case. Again, it's unbelievable that at your age, you have no prior criminal history, and now you sit here convicted of the most serious of charges. I also have to...
Again, is a big deal. Like, people usually don't go from nothing to this. And that's why, you know, there's been some criticism around people, including from myself, talking about Kohberger, but he hasn't been convicted yet. It would be wild there too, that he went from nothing to this, which is why other people are trying to find other crimes that he's committed. But it is absolutely wild. This judge sees a lot of these cases and he knows it. He knows that it's very unusual it's kind of like a gateway. There are gateway crimes. You know, you start out with certain things, and then eventually you get to the most heinous of crimes. Not that everybody's like that, but that's the one mitigating factor, is her criminal history. But again, the fact that she has other charges pending kind of hurts that one mitigating factor.
Consider whether the criminal conduct was the result of circumstances unlikely to recur. Based on the evidence in this case, and in particular, considering the statement you just made to the court, I find it weighs against me finding in mitigation for that factor.
So her statement actually hurt her. So he's saying, is it likely that something like this would happen again? And I mean, you could say no, because these are her kids. These are the roadblocks the state argued in the case. And maybe she doesn't have any other roadblocks, but she does have at least one other kid. And basically what she told the court is she knows they're fine. She knows they're in the spiritual realm. She talks to them. She knows best. And so if there's anybody else that comes in her path and she thinks needs to go to the spiritual realm, she will send them there. and therefore people are not safe. So based on her, I mean, she didn't say that exactly, but that's what you can infer from her statement in the court saying, no, because of your statement, this is not a mitigating factor. So her statement actually hurt her in the judge's mind in his sentencing. Although, again, I don't think it made a difference either way. I think the judge was always going to throw the book at her.
And then finally, the character and attitudes of the defendant indicate the commission of another crime is unlikely, or the defendant demonstrates amenability to treatment. So those are the mitigating factors. Then
Again, her statement does not show that. It does not show that she thinks she did anything wrong and she agrees and she wants treatment.
Aggravation, we have more factors to consider. Is there an undue risk that during the period of a suspended sentence or probation, the defendant...
Now we're going to go through the aggravating factors, which make him more likely to give her a harsher penalty.
Would commit another crime harmful to another person? Would a lesser sentence depreciate the seriousness of the defendant's crime? Will imprisonment provide appropriate punishment and deterrent to the defendant? Will imprisonment provide an appropriate deterrent for other persons in the community? And a factor that would not apply here is the defendant a multiple offender or a professional criminal. I don't have an LSI score, which is one value I can look at to help determine whether or not you'd be likely to reoffend. I don't have that because you wouldn't cooperate with the report. So considering here,
again, that's something that could have helped that he doesn't have because she didn't do it.
That you've lived a law-abiding life, and for a long time, you were obviously a good mother, sister, daughter, and friend to many people. I have to take that into account. You've served a very long time of local jail, over 1,200 days, and the report is you've been a great inmate, never caused a problem for anyone in the jail. And you should be commended for that. And that also shows that you are capable of that. I believe your counsel, when they tell me you're an intelligent person, up until all these events began to transpire, you've achieved goals in your life, you've done important things in your life. And I'd note that despite some of the comments here today, I have found that during my interactions with you throughout this long case, including your trial, you've been respectful of the court.
Besides today.
Do we know what this beeping is that keeps going off? Sorry. All right, the court will next consider, and I think it must be considered in mitigation, that you do have mental health issues. I've dealt with those throughout the context of this case where there were commitment proceedings.
So even though she didn't do the pre-sentence investigation, he is still going to be considered a mitigating factor because he has dealt himself with her mental health issues.
I've reviewed those reports and have that personal information from having gone through the determinations of whether or not you were competent or fit to stand trial. The most current diagnosis the court has is from Dr. Watson, and from February of this year states you suffer from, and I'll quote, delusional disorder, mixed type with bizarre content and hyper-religiosity, continuous and unspecified personality disorder with histrionic and narcissistic features. So obviously a very complex diagnosis that's been made here. Whether or not that can or how it would be treated, I think by all accounts is unknown at this time. I've reviewed your personal history, including statements from your own immediate family members, and it's clear that something radically changed in you that led you to where you are today. In a statement made in the pre-sentence investigation report, your mother stated it perhaps best and said that you are not now, quote, the person she knew. The record in this case, including all the evidence I observed during the jury trial, indicates that if it wasn't already occurring, that this relationship with the co-defendant seemed to be a catalyst for the change. At this point, I'll note that I will not be making comments on any other co-defendants in this case, as your co-defendant is currently presumed innocent and awaiting trial.
So he's basically going to say, I'm not going to blame him for the crimes that you committed or push some of the guilt on him or liability on him because he's presumed innocent. You're the only one guilty of committing these crimes. So the timing of these trials worked out poorly for Lori Vallow, but her team felt like it was necessary to demand speedy trial. Daybell's team continues to ask for continuances. So, that's something that, again, is a knock during the sentencing phase. But you only get to sentencing if you lose. So it's easy to Monday morning quarterback it.
In sum, there are significant mitigating factors the court has to consider here when I consider you and your life as a whole, and that does make the case difficult. Typically, when I see somebody to be sentenced and they don't have a prior criminal history, they're given opportunities to first prove themselves on probation or avoid a lengthy term of incarceration. However, of course, some crimes are so serious that even with mitigation, there is no other reasonable option except for a prison term and a long prison term. And sadly, you've been convicted of and have committed the most serious crimes possible, and those crimes also require an equally serious punishment. So this is the part where I will consider what I think are the factors in aggravation. I went through those factors in the statute.
All right, so here's what's aggravating to him.
Statute that I look at, and as I'll explain, I find that 5 of those factors weigh against you and in favor of a lengthy period of imprisonment. First, the case itself. I'll discuss that. There was a lot of pretrial litigation in the case. You decided to take your case to a jury trial. I will state and emphasize that I firmly believe it's the right of every person in our country to exercise their right to a jury trial, and they're afforded the full due process of the law. It's been somewhat disheartening to me to realize that there are many people who think that they can predetermine a case and somebody shouldn't be afforded their full rights of due process before they are convicted of a crime. Well, I didn't make all of the rules that govern criminal cases, but I took an oath to uphold the rules that are there, and I make every effort to ensure that people's due process is protected because that's an important duty of mine. Everyone has a right to be presumed innocent, and everyone in a criminal case does have a right to a jury trial. Sometimes I feel like maybe too many cases settle, and there should be more trials because it's a right people are entitled to exercise. You exercise that right, and I in no way hold it against you that you decided to have your case determined by a jury. That's your right, and it does not impact or influence my decision in sentencing. Before trial, I did not delve into all of the evidence.
I love that. I do believe it the way this judge says it. Not all state attorneys agree, and definitely not all judges agree that they may say, because you go to trial, I'm not going to give you a harsher penalty. But I've literally had state attorneys saying, well, if you go to trial, it's going to end up worse for you if you lose at the end, which is absolutely horrible and should not be the case. And I appreciate that this judge said that. The fact that you got a defense and went to trial, which is your right, I'm not going to hold that against you. Good. There's plenty of other things to hold against her.
Or facts of this case and only address those when necessary to make rulings on motions, because I wanted to keep objective through the proceedings and remain impartial. You were afforded all of your due process in this case, and ultimately, after presentation of the evidence, the jury did find you guilty on all counts. I bring that up now because when there is a trial, I learn and see all of the facts along with the jurors. And that's a different scenario than when someone enters a plea and I'm only allowing argument in a sentencing and not sitting through the evidence as I did here. Having considered all of the evidence that I saw at trial along with the jurors, it's been a difficult task for me to narrow down and articulate all of the aggravating factors because really there are so many here. Murder is the most serious offense. And the most unimaginable type of murder is to have a mother.
And he is right. There are so many here.
Mother murdering her own children. And that's exactly what you did. You were involved in and guilty of conspiring to murder another group of children's mother, Tammy Daybell, who had children of her own. And despite the jury convicting you with overwhelming evidence, you still sit here before the court today and said you didn't do it.
No judge likes that. That's what I was saying. When she was saying, I didn't do it. I know they're fine. You guys don't realize there are accidental deaths and this and that. Courts hate that. But I mean, most people still do it, especially when they plead not guilty and maintain their innocence the whole time. So it's not unusual, but almost every sentencing, the judge mentions how that's an aggravating factor.
You came here to East Idaho, where I've spent my life, and moved here from another place already with plans in progress to make your children disappear. The evidence bore that out at trial. You removed your children from their home in Arizona, alienated them from friends and family, got rid of JJ's service dog. You moved to Rexford, a community where you could find 1,000 random families to take your children, and you brought them here and murdered them. You had so.
I feel like you can see and hear in the judge's voice how sad he is and broken he is about this, about how horrible these facts are and what she did to come here just due to that, to his little town where thousands of families would have happily taken these children. It's brutal. It is a brutal set of facts in this case.
So many other options. You could have gotten divorced. You could have found someone to take care of those kids. But as the state was able to prove at trial, you chose the most evil and destructive path possible. You killed those children, according to the state's theory, and I believe it, to remove them as obstacles and to profit financially. You justified all.
He believes the state's theory, and that's okay at this point. The jury agreed and convicted her.
All of this by going down a bizarre religious rabbit hole, and clearly you are still down there. While you were enjoying your new life in Hawaii, countless law enforcement officers, family members, and volunteers were searching for your children. And I don't think to this day you have any remorse for the effort and heartache you caused for others who looked for your children when you knew where they were and knew they were dead. They were found dead, burned, mutilated, and dismembered, and buried like animals. After you knew they were dead, you collected public-funded assistance payments meant for them, and that was blood money you kept for yourself.
Despicable, man.
And that's the grand theft charge you've been convicted of. Your sister, your son talked to you, begged with you while you were in the jail during phone calls I heard at trial, and those were very sad and difficult calls to hear, and you didn't provide any assistance or comfort to them. During the trial, when the evidence came out about how these children were found in the state they were in, you wanted to be excused and not have to watch the evidence, and were fine to let all the other people in the courtroom, including the jurors, have to bear through that. However,
again, her actions spoke loudly. Everything she did throughout the litigation, throughout the trial, everything she said today, he is looking at her for responsibility, and that's totally appropriate. The court's allowed to do that. He is sensing her as a person. You look to their past, no prior record. You look at their future, other charges pending. You look to how they were throughout this case. You look at the evidence. You look whether it's proven. You look at how bad it is and what a danger to society you might be. This is how sentencing works. Like I said, we've watched a few of them, and everything we talked about as a community, her not wanting to be there, how horrible that is for what she did. She didn't want to look at it. She was spending their blood money when they were gone, and she knew they were gone, and she made them disappear for the money and the power.
I ruled that you did have to sit and watch and see the result of your heinous crimes. The jurors in your case fulfilled
Now,
their
if you
duty.
want to nitpick, he made her see the result of her crimes. He didn't know they were her crimes yet because she was presumed innocent, but
Admirably. All 18 jurors we had, because we had alternates, went through the entire trial and faithfully fulfilled all their obligations and all the instructions. So we were able to get impartial jurors who weren't already tainted by pretrial publicity to decide your case. And I do thank the jurors publicly for the service they rendered. Those jurors I noted during the trial were very good at keeping their emotions in check and keeping stone-faced, as they're supposed to do, and be objective until the case is done and submitted. However, I did note at certain times during the trial, such as when there were videos and pictures shown of you in Hawaii at this time frame when JJ and Tylee were lying in shallow graves, the disgust on the faces of those jurors was evident, and shocking revelations about what happened here just kept coming through the trial.
and the discuss in the chat, right? Sometimes chats can go overboard. Sometimes chats can be wrong, but most of the time, this chat has a finger on the pulse of the jury, and the disgust that we all collectively had in this community seems like it was shared by the faces of the jurors in the courtroom during the trial, and the judge is pointing that out now. And I think the judge agrees with that as well.
The crime scene was a horrific thing to have to review, and there's images that I will never get out of my mind. And I'm just looking at the pictures. Law enforcement officers who had to deal with the aftermath of what you did, I'm sure were traumatized. And I know it was traumatic as well for the jurors who had to sit through and see the photographs of these dead and mutilated and buried children. For those people who loved and cared about JJ and Tylee and Tammy Daybell, to have to see those photographs of them through trial of their dead and desecrated bodies must have been devastating. Tammy Daybell was murdered as a result of your conspiracy. She was, by all accounts, a healthy, happy mother and wife through a lot of her life. And you were out shopping for wedding rings to marry her husband while she was still alive. You were planning a wedding to her husband while she was still alive. You haven't shown any remorse for any of those actions. And she ended up being murdered, buried, had to be disinterred later so an autopsy could be performed in order to prove the evidence of what you had done. She didn't deserve any of that. You took her life away. You destroyed that family, fractured it to the point where, in the information I've had through the PSI, there are relationships that will probably never be mended that have rippled as a result of what's happened. JJ and Tylee, of course, 7 years old, 16 years old, were separate people whose lives were cut way too short because of you, never got to grow up and be adults. The family and friends who have provided their impact statements, of course, have stated it better than I could about who they were. And it is a loss for everyone that you took them away from this world. And it is the most shocking thing, really, I can imagine, is that a mother killed her own children and you simply have no remorse for it. Even sitting here today, there's no remorse for what.
And that's big. Like we've been saying, again, what the victim said, how they explained them, the lives that were lost, the pain that continues on afterwards, and then no remorse.
You did. After all of this evidence through trial, you haven't shown any remorse. You haven't said you're sorry. You haven't done anything to seek leniency from this court.
Just to be clear, she could say she's sorry 1,000 times. I don't think it would have changed the sentence. If you want my honest opinion, right?
There's been a lot of people during trial and here who explain the devastation you're responsible for, and you forever altered the lives, not in a good way, for many, many people, destroying family relationships, taking people away that were loved, cared for, and needed. You may not believe to this day that you've done anything wrong, and you still may think you're justified by your religious beliefs for what happened here. I'm not here to judge that, but I don't believe that any God in any religion would want to have this happen, what happened here. And your crimes are heinous and egregious, and that alone can constitute a major aggravating factor.
And again, he said, I'm not here to judge your religious views either. I think that's how you're justifying it to yourself. But again, that doesn't absolve you of any criminal liability. And I don't see how God would want that to happen, right? Just, He's a human. He's a judge. He's applying the facts to the law.
Requires me to impose a serious length of incarceration. So after weighing all those factors, I need to, in aggravation, I find that the sentences I'm about to impose will serve the interest of justice by, number one, preventing you from ever doing this again, that they will not depreciate the seriousness of your crimes, will punish you appropriately, and will serve to deter both you and others. So
And again, depreciating the seriousness of the crime, I think, is why he's going to eventually, I haven't heard this, is why he's eventually going to go with consecutive sentences. Probably, I would think. I don't know. Maybe he won't. But to appreciate the seriousness of each individual person that she hurt, running them consecutively would appreciate the seriousness and specificity of the crime committed on that person. Not just that it's one life, it's Lori Vallow's life. She committed all these crimes, just one life sentence, but maybe stacking them for that reason.
concludes the aggravating factors the court considered. At this time,
We talked about this in the Darrell Brooks case as well.
and I am prepared to pronounce sentence. Mr. Thomas, Mr. Archibald, and defendant, would you please rise for the pronouncement of sentence? Based on all the relevant circumstances, including the evidence and recommendations presented in court today, it's the judgment of this court. Ms. Vallow, you'll be sentenced as follows. I'll first note I'm going to take up the counts out of order as I want to address the substantive murder sentences first. So on count 2, the charge you were convicted of, the first-degree murder of Tylee Ryan, you are sentenced to the custody of the State Board of Corrections to serve the maximum allowed sentence, a fixed determinate term of life imprisonment with no possibility of parole. On count 4, the charge of the first-degree murder of Joshua Jackson Vallow, you are sentenced to the custody of the State Board of Corrections to serve the maximum allowed sentence, a fixed determinate life imprisonment sentence with no possibility of parole. I'll next address.
I don't know the parole rules in Idaho, if I'm being honest, but life with no parole is the maximum sentence as he described. And that's what he's sentencing her with, throwing the book at her, as they say, maximum sentence, aggravating factors, the worst of the worst, basically. That's what she's getting. So if it would have been up to him and death penalty was on the table, what do you think he would have done? But let's continue to listen to see if they're consecutive.
The 3 conspiracy counts you've been convicted of. And note, under Idaho Code 1817-01, the punishment for those crimes is the same as the underlying offenses you combined to commit. One of the offenses you combined to commit was first-degree murder, so those may be punishable also by imprisonment for life. When I look at what the appropriate sentences should be for the conspiracy charges, at first I wondered if they should be as long of a term or serious as the substantive murder charges. However, what I've concluded is that these conspiracy convictions merit the same grave punishment for several reasons. First, the conspiracies in which you engaged in have had far-reaching impacts on many people besides the deceased victims. And with what the court's heard, I am convinced that the conspiracy charges also merit the same serious sentence. So on count 1, the conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception, you're sentenced to the custody of the State Board of Corrections to serve the maximum allowed sentence, a fixed determinate term of life imprisonment with no possibility of parole. On count 3, the conspiracy to commit first-degree murder of Joshua Jackson Vallow and grand theft by deception, you're sentenced to the custody of the State Board of Corrections to serve the maximum allowed sentence, a fixed determinate term of life imprisonment with no possibility of parole. And on count 5, the conspiracy to commit the first-degree murder of Tammy Daybell, you're sentenced to the custody of the State Board of Corrections to serve the maximum allowed sentence, a fixed determinate term of life imprisonment with no possibility of parole. Finally, the court will address count 7, which is the charge of grand theft. On that charge, court is going to sentence you to a fixed determinate term of 5 years of prison, followed by an indeterminate term of 5 years of prison for a total 10-year term of imprisonment on the grand theft. Court will next consider whether sentences should be imposed consecutively or concurrently.
So this was really the only question, right? This was the question we're kind of waiting on. We knew it was going to be multiple life sentences. Is it consecutive or concurrent? I think it's going to be consecutive. I think it should be consecutive, even if it's just symbolic. I think in this case, it makes sense.
I generally don't, I'm a pragmatic person, and I've struggled with the point of a consecutive sentence when in Idaho, a life sentence is just that, a life sentence without parole.
I agree.
And I've thought it through. However, when I looked at this case and the more I thought about it, I've determined that because there are 3 separate murders with 3 separate victims that occurred at 3 separate times, then running counts concurrently would not serve the interest of justice, because those crimes all need to be taken into account separately and distinctly and individually. And you need to be held accountable separately for each of the 3 murders. So on those counts, the court will run consecutively the count 2 murder of Tylee Ryan, consecutive to count 4, the murder of Joshua Jackson Vallow, and count 5 will run consecutive to count 2 and 4, the conspiracy to commit first-degree murder of Tammy Daybell. So 3 consecutive life terms of prison. The remaining counts will be concurrent. to the counts that are consecutive.
So 3 life sentences stacked on top of each other. Everything else concurrent means served at the same time as those 3 life sentences, symbolically and for justice for all 3 individual victims specifically, kind of like I talked about off the top. So, I mean, it makes sense. And I'm pragmatic like he is. Doesn't really make a difference. It's still 1 life sentence. But again, a lot of you have shed light over the trials that we've kind of gone through that it does make sense. And it does make you feel a little bit better as the public, as society, as a community, as family members and loved ones of victims, that your individual victim gets a life sentence attached, even if it doesn't add any actual literal prison time. It makes a difference. So again, we're all learning here together. And over the years, I've come around to that as well. Because years ago, I would have just said 1 life sentence. It doesn't make a difference, especially without parole. But I think you all are right. And the way to look at that more as a human being, rather than being so pragmatic about it legally and literally, has been helpful. And I agree with the judge's decision here.
The court will impose fines as requested by the state in the amount of $25,000 for all counts except the grand theft. On the grand theft, the fine will be in the amount of $1,000. The court will assess the civil penalty that was requested, and I find it's appropriate under Idaho Code 195307 of $5,000 per victim on each of the 3 victims as a civil penalty. And then finally, the restitution, which was requested by the state. Mr. Wood, if you could reiterate that number, 22,000 of what the restitution term is. And I want to inquire if there's any other restitution being sought by the state.
Your Honor, I believe I said $22,545 victims who
Have charge of $22,545 as shown through the evidence at trial. And the court will allow 30 days for additional restitution requests, but that will be waived if it's not submitted timely. That'll conclude the court's sentencing on the charges. Mr. Thomas, do you have any questions on the sentence?
No, Your Honor, thank you.
All right, Mr. Wood, do you have any questions?
No, thank you.
All right, counsel, before we conclude, and Ms. Vallow, importantly, I need to advise you of the rights you have now. You do have the right to appeal to the Idaho Supreme Court from this judgment of conviction, and you have a right to be represented by an attorney if you appeal. You're also advised if you can't afford an attorney will be appointed for you at public expense, and you only have 42 days to file an appeal. You also have the right to seek relief from my judgment under Idaho Criminal Rule 35. You have 120 days to file that motion if you believe a correction or reduction of this sentence is appropriate because it was either illegal or too harsh. And finally, you may also have rights to seek relief under the Idaho Uniform Post-Conviction Relief Act. Those actions have to be filed within 1 year from the day your right to appeal expires. Do you understand those appellate rights? All right, she acknowledged yes. The defendant will be required to submit DNA samples upon remand to the Idaho Department of Corrections. I'll ask the attorneys to please turn in any copies of the pre-sentence investigation reports or addenda so those can be kept in confidence and additional copies will be destroyed. And Ms. Vallow, you are hereby remanded to the custody of the Sheriff of Fremont County to be delivered to the proper authorities of the Idaho Department of Corrections for execution of this sentence. Thank you, ladies and gentlemen. That'll conclude our sentencing hearing.
All right. So that's it. She will appeal. She has the right to appeal. She will appeal. The sentence is not an issue. Nobody's going to find that was too harsh for the penalty. I think it might be even the minimum sentence for some of these crimes that she was committed of or convicted of, but she will appeal the trial. She will appeal the case. And we'll just have to continue to follow and see if anything has any merit. I don't see where there would be any, except for the speedy trial issue. That's really the only appealable issue I think that might hold some water if they violated her speedy trial rights. So we will continue to watch and listen for that. If you are interested, like I said, you can let me know by commenting and hitting that like button. That's all we've got on Lori Vallow Daybell sentencing. Let me know your thoughts in the comments. I know it was a tough day. Let me know if you agree with the judge. Let me know what you thought of Lori's comments. I mean, it was interesting to hear from her for an extended period of time. Thanks for joining me. Hope everyone has a good night, and I'll see you on the next one. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.